to Doug Hausman, a board member on the Elder Law section, who will be introducing our speaker today.
Thank you, Anne. I do have the privilege and the honor to introduce Joseph Morrill. So Joe Morrill is the founder of Morrill Law Firm with more than 20 years of experience as a litigator. He focuses on cases involving will and trust dispute, financial elder abuse, fraud, conservatorships, and related claims. He represents private professional fiduciaries, trustees, executors, agents under durable power of attorneys, conservators, and other fiduciaries, trust beneficiaries, heirs, nursing homes, elders, and the family members of friends of elders. So essentially every human he represents. Joe's extensive trial experience includes both bench and jury trials. He's obtained multiple defense verdicts representing trustees against actions contesting trusts and alleging lack of capacity, undue influence, breach of fiduciary duty, fiduciary accountings, and financial elder abuse. He's also obtained jury and bench verdicts, judgments, and elder abuse writs of attachments representing beneficiaries, elders, and other interested persons. Joe routinely appears for hearings and motions and is well versed in all aspects of discovery, including expert witnesses. One thing you may not know about Joe is that he is, in fact, a certified mediator and has substantial experience in settlement negotiations and mediation. And he serves in the Contra Costa Court Alternative Dispute Resolution Panel of Neutrals. Whew. So this is a perfect topic, trust and conservatorships. Just as a forewarning, we are not going into the basics of trusts and conservatorships. Joe's speaking in regards to kind of the interplay of all of that and the more technical day-to-day scenarios that he faces or has faced in the past. So without further ado, ladies and gentlemen, boys and girls, individuals of all ages, I give you Joseph Morrill.
Thank you very much, Mr. Doug Hausman, Esquire, for that rousing introduction. Thanks also to the Elder Law section for inviting me. I also need to thank my associate, Sarah Krasner, for helping me with the research materials and the PowerPoint, which I could not have done myself. As Doug mentioned, I'm going to have a few assumptions, or I made a few assumptions in presenting this today. One is that everyone has some experience working in cases with conservatorships and trust actions simultaneously. It's not a beginner's course, but I did try to intertwine stuff in there for everyone from younger lawyers to grizzled old gray bearded ones. A couple other assumptions I made is that based on the assignment I received, that the proposed conservatee has a trust and probably verbal powers of attorney, and that the settlor is still alive and the beneficiary of a trust. My focus is, just because of my background, is more on contested matters, focused more on money. In my experience, while we do often deal with issues on the healthcare side of things or conservatorship of the person side of things, for whatever reason, humans usually are more focused on the money, and that's usually what drives our cases. And I tend to focus more on strategy and practical tips as opposed to black letter law or day-to-day mechanics of administration. There is a lot of law in the materials that you guys can check out. I'm going to focus more on strategy. My general approach to MCLEs, whether I'm speaking or attending, is that I want to pick up a few things out of the MCLE that changes the way I approach things, right? Like that changes my, whether it's checklists that I use or just thought processes, whatever. I don't like it when I go to these and someone just reads law to me. I assume that everyone who passed the bar knows how to read and conduct research. And I also would assume that most of the people in the audience can do research better than I can at this point in my career, because I frankly don't do a lot of it anymore. I focus more on strategy and storytelling, developing the theory of the case, discovery. So if I walk away from an MCLE changing something because of it, I think it's been a success. I'm going to share some of the ways I approach the interplay between trust and conservatorships. Incredibly broad subject. I think it could be, 10 plus hours. I know the CEB on conservatorships is, well, the old fashioned version is three ring binders, and the trust is 2 or 3, I think. I'm going to start out today with some of my favorite kind of tips, kind of a greatest hits of things that I think are do's and don'ts. Most of them are just my opinions. So you can take what you like and send back what you don't. Some are probably really obvious to people that have been practicing. Hopefully I can slip in a few more unique pearls of wisdom as well. And then I'm going to go through the PowerPoint and hit on several of the issues again, but in context. As they mentioned, I'm going to leave 10 or 15 minutes for questions from the chat. And that's really the plan. So hopefully I say something that causes you to change your approach a little bit. And so now I'll try to get started with the technology part of things here. So I want to hit the question that was in the ad regarding today, kind of right out of the gate, which is, what do you do when you represent the conservator and the trustee is the one controlling the purse strings? Which my short smart aleck answer is the same answer I give to everything, because I think it's the only tool we have in our toolbox as a lawyer. Is we ask nicely, usually in the form of a letter and email, and then we file petitions when the target of the correspondence ignores us. And so what type of petitions usually come out of the gate when you're fighting over the money? And hopefully, usually the money's in the trust, not in the conservatorship estate. I think if you have the cards to do it, you turn them over and you try to get the trustee replaced. And by cards, I mean real evidence of misappropriation or breach of duty with damages that actually justify the attorney's fees that you're going to expend. I don't mean things like that the trustee spent too much money on dog food or going to fast food restaurants or airline miles or things like that. I mean, in order to get someone suspended, you should have real evidence of money leaving the trust and going into the trustee or someone affiliated with the trustee's pocket, or the trust losing money at a level that justifies our hourly rates and, in tandem with all the other lawyers as well. One thing I like to hit right out of the gate, because I see a lot of attorneys do this, whether they're new or experienced, and they tend to conflate things, particularly when they're going in ex parte. Removal and suspension are 2 totally different things. And you should plead removal in your main petition, your underlying petition. Removal requires a trial, or at least an evidentiary hearing, or it should. And it's permanent. Whereas suspension under probate code 17206, that is temporary. And that's where the court has broad powers to appoint a temporary in order to protect the estate. So one quick detour, always warn your client when you represent a trustee and someone has filed a petition to remove, always immediately warn them that suspension is a distinct possibility and that it can come in the dead of night in the form of an ex parte. Make sure that you tell them that that is a possibility, but you have a plan. And that if that occurs, you can pivot to that plan, and that you still have options as a former trustee and or a beneficiary. You don't lose your rights and can file petitions for instructions, et cetera, to get the person that replaces you moving. And you still are going to have a trial at the end of the day on whether you're permanently removed. It's just a way of keeping expectations in check. Clients get really really upset, justifiably, when out of the blue, you have to call them and tell them they've been suspended. If you don't have the cards, if you don't have evidence that would allow you to go out and try to get the person replaced right out of the gate, you'd file a petition for an accounting, trying to gather some intelligence and some information there, and set the stage for possibly suspension or removal down the road. And you can file a petition to instruct the trustee what you want her to do. And so that's kind of a Captain Obvious answer to that main question. But I wanted to hit that out of the gate. Now I'll move to sort of my approach, some of the do's and don'ts that I have before I go through some of these things in context. First of all, in the interest of full disclosure, I think I should start by saying that I absolutely hate conservatorships. They're a necessary evil at best, but I generally despise them. Like Gollum hates Bilbo and Frodo, and like Anakin hates Obi-Wan, I hate them and try to avoid them whenever possible. That being said, I fail a lot because sometimes they are the only, or at least the best option, or someone else drags you into one. Why do I not like them? They're expensive, both financially and emotionally, particularly for the individual that we're trying to quote unquote protect. I also think we get into situations immediately where there are too many cooks in the kitchen messing with my theory of the case. Court appointed counsel, court investigator, there's a bunch of parties that come with a baggage that comes with conservatorships. Also, I just don't believe that courts or lawyers are very good at solving problems for families. Sometimes we have no other option, but in general, philosophically, it bothers me a little bit. Also, post-January, the court-appointed counsel now oftentimes has to object and push for a trial, and not just a trial, a jury trial. And so I think as we go forward, we're going to be bogged down in more long, even nastier wars than we have historically, because court-appointed counsel will feel obligated to object and go to the end. Another reason I don't like them very much is clients and myself are simply very seldom happy with the outcome. Even when we believe it's a good outcome, it almost always takes too long and costs too much money. Ironically, some of my most or least happy clients have been in conservatorships where I believe I've done some of my best work. I don't know what it is about it. It just seems to happen. So there's my opening caveat that I hate conservatorships. That'll bleed through all of this that I'm going to say today. My second tip here is to realize and focus on the fact that your real goal, that your client's goal should be, if it isn't, settlement. They're on a train to trial, and going to trial, even if you win, is generally a loss. You're going to spend so much money that it is not going to feel like a win. So I always try to start convincing my clients of that truth from the get-go, that the goal is to settle. Not settle for settlement's sake, but to settle on our terms, right? And what do we need to get to be able to do that? Third little tip here is to read the trust if you at the very beginning, and then read it again and read it again. The probate code provides all the general rules that govern trusts, but the trusts that good estate planners draft tweak those rules. And so I often find that lawyers are in court arguing the general rules when the specific rules that are in the trust that we're arguing about deviate from the probate code. The main ones that pop up again and again are what is the level of discretion the trustee has? What are the rules about accountings? Is there any limitation of liability for the trustee? Often trusts will limit it to intentional acts or gross negligence. Meanwhile, the petitioner is claiming they did something that is just ordinary negligence. That's embarrassing when you're arguing things that the trust clearly allows. Similarly with self-dealing and trustees being able to retain unproductive property. I've had that happen several times where people are filing petitions arguing that the trustee was not making productive or property productive, when in fact the trust specifically stated that the trustee could do that. Another one, another don't, I kind of hit on this earlier. Don't file a conservatorship unless you have to, unless it's appropriate. Some attorneys seem to file conservatorships in every single darn case. Don't be that attorney. That's lazy at best, in my opinion. Use the estate plan, file a trust or a power of attorney petition if you can to get your client's goal. It's cleaner. You can make it much more surgical. And it's generally, which I'll get into later, an easier burden to meet. I hate ex partes almost as much as I do conservatorships. No one seems to remember that they require a good cause and they're actually supposed to be an emergency. It seems most lawyers like to use them to minimize the amount of time their opponent can respond, which is inconsistent with due process. So don't weaponize ex partes. That misuse can come back to bite you, and it can be very costly if the judge later on concludes that they've been misled early on in the case. Also, another reason I hesitate often to go out ex parte, unless I know I have overwhelming evidence. If you lose ex parte and the order goes against you, very difficult to get the judge back on your side of things. The judges don't like to back up. And so if you miss that first shot, you can be stuck with it. Another one, don't waste clients' time or court time, because time is money, on do-overs like demurs or discovery that you're going to have to produce. With respect to demurs, unless it's a statute of limitations argument or some other argument where you're going to knock a cause of action out completely, you're just they're going to have leave to amend. They're going to get to do it over again. So to quote Robert Duvall in a civil action, if you're going to hit a guy, do it so he isn't going to get up. I completely agree with that. Keep in mind that every estate that you're dealing with has a finite amount of money in it. You and your work is not going to increase the amount of money in the estate most often. We are, as I often tell my clients, people like to characterize lawyers as vampires. It's an accurate analogy, except we suck estate money, not blood. So keep that in mind. Similarly, don't waste your time on 128.7 motions. If you don't even know what that is, don't even bother looking it up. They're useless. They don't do anything except make judges disrespect you. Next tip. Again, I'm going to quote Robert Duvall in The Godfather. He says at one point, Mr. Corleone, who's Vito Corleone, the crime boss, is his only client, and he insists on hearing bad news early. I have stolen that, and I try to instruct my clients that they want to hear good or bad news early as possible in our relationship as well. I want to get the medical records. I want to get the drafting attorney's file. I want to get a 7:30 neurological exam as early in a case as I can, because I want to know if I'm going to have problems, and I want to address those problems with my client. The only thing worse than getting bad news is getting bad news after you've spent $100,000 plus, when you could have gotten that bad news a lot earlier. The other thing I want to do early is ID the witnesses and discuss them with my client, because it's amazing how often you'll get a list of witnesses and you'll sit down with your client and you'll say, oh, the other side says that Aunt B is going to testify against you. And your client will say, nope, talked to Aunt B yesterday. She's on our side, no big deal. Or I'll say, okay, what about Uncle Elmer? And they have a look of horror on their face and say, oh, I didn't think of Uncle Elmer. That's a problem. And then I'm like, do tell. Let's get through this right now. And I think this isn't, a lot of people don't have this attitude. I had a interaction with a lawyer who I have a great deal of respect with a few years ago, who was actually quite snarky with me. I was suggested that we call a timeout in the case and get a neurological exam, because I was claiming that the elder lacked capacity, and he was steadfastly saying that she was fine. And it was obvious that we weren't going to get anywhere until we had her evaluated. She was alive. And he's kind of sneered at me and said, what happens? What are you going to do if it turns out she has capacity? And I hope I professionally responded without being snarky back. Well, then I'm going to sit down with my client and explain it's time to cut bait, and we're gonna have to figure out a way to settle this thing. I think that's the proper way to approach this stuff. I'll get into this one in more detail later, but the short version is, don't ask the court to appoint a private professional fiduciary because the kids or the family doesn't get along, or there's hostility amongst the beneficiaries only. If that's your only ground, that is not going to win the day. On the conservatorship side, the case Conservatorship of Ramirez, which is in the materials, it's at 90 Cal. 4th 390. It's a 2001 case. Read it. Try to take the opportunity to force or inspire every judge you appear before to read it too, because I found that judges often appoint PPFs based solely on hostility. In this case, rules that a nominated family member trumps a PPF unless someone can make a showing that that person that the elder nominated is unfit or not in the best interest of the elder. So basically, you have to show things about that person that, in my opinion, would amount to removal. And the rationale of the court was quite interesting. And it's that PPFs really have no more power than anyone else to make the family members get along. In fact, it often makes it worse. And what the only way you can get people to do what they're supposed to do, you probably can never make them get along. But the court is the entity with the power to issue orders that will hopefully improve the situation. And that was the rationale behind the court's ruling. On the trust side of things, if you're arguing hostility amongst the beneficiaries, that can be a ground, but not if the hostility existed at the time the trust was created, or that the hostility is secondary to the litigation itself. One of those two things, if not both, are almost always present. It's either a Cain and Abel case where the siblings can't get along. They haven't got along since they were 12, and the parents were well aware of that. Or the kids don't like their evil stepmother since the day dad brought her home, right? And so I've just found that those two things waste a lot of time and effort and attorney's fees. So the other reason I favor using petitions for instructions to get the trustee or an attorney in fact to do what you want them to do, instead of filing a conservatorship petition if I can, because the the main idea or the hurdle you're facing with conservatorships is it has to be the least restrictive method available. And that almost always is the existing estate plan. The issue is someone's not following it correctly. The trustee's not doing their job correctly. So conservatorships are kind of off the mark often because the money's not in the conservatorship. The fight is bigger and more expensive and more difficult to win than a targeted trust petition would be. We're usually arguing over who should be. No, take that back. The argument is who should be managing the elder's money. Is this person the right trustee or attorney in fact, or should they be replaced with someone else? That's a much easier argument to make than we need to strip grandma of all of her rights and conserve her. Now, I know that conservatorships they're very malleable and they can be used. They're not one size fits all, but they do come with a lot of extra stuff that a trust petition doesn't. And I just think that the argument flows a little easier and doesn't cause also the extreme reactions that you get out of elders when you're attempting to conserve them because you have to allege that they can't handle their own affairs. So before you file a conservatorship, always ask yourself, what are you trying to accomplish? Usually you're just trying to protect grandma's money from herself and those around her. Always hear clients say, I just want what's best for grandma, or I just want to honor my parents' wishes. And I've always joked around and put in parentheses after each of those sentences, as long as I get her money, because that's really what they're usually saying in my experience, especially the ones that hammer away on that over and over and over again. So there's the question. Is there a way to accomplish that goal, protecting the money without filing a conservatorship? Usually the answer is yes, if you have a trust, right? If you don't have an estate plan, okay, you got no choice but to file a conservatorship probably. The other situation historically where I often found myself deciding to go forward with a conservatorship is the undue influence situation, where there is a fox in the hen house that has grandma captive, either physically, psychologically, or both, right? And I need the court investigator and or a court-appointed counsel as that neutral who can get behind the curtain with the fox and kind of shed some light on what's going on inside the hen house. However, as I mentioned a little earlier, I'm afraid that court-appointed counsel may not be as helpful now as they were in years prior. And the opposite effect may occur where they actually feel like they have to go to the mattresses, And so I think it's arguable that filing a trust action or an action under the durable power of attorney and asking the court to appoint a guardian ad litem may actually be a better tool for dealing with the fox situation than court-appointed counsel in a conservatorship. I honestly haven't had enough experience under the new regime to make a conclusion yet, but I think it's at least worth thinking about. I don't know the answer. If you do decide to file a conservatorship, one tip I would give everyone is not to fight the forms, the judicial council forms. I see lawyers all the time trying to jam their case into the little pre-printed boxes, forcing the court to turn back and forth amongst all the pages. I think, and I've been told by examiners and a couple of judges that they would prefer if you just check all the boxes that say see attached. And then what I do is I use a summary or an introduction, paragraph or two in Word format, where I tell the story in a chronological fashion that's very simple, so that right out of the gate, the judge can read a page and know what's going on, what has happened. And more importantly, hopefully when they read the story, they want to do something about it. That's your goal, is to get the judge to want to help you out, to want to give you what you're asking for. Then you ask for your relief in the form of an order. You tell the judge what it is you want, what you're seeking, and at the same time, you provide authority so the judge feels comfortable that she can grant the requested relief. I do that in every pleading. I'm just a huge fan of using introductions to set the stage right out of the gate. You do not want the judge to have to read 7 pages to find out what it is you're asking for. You want them to read your entire story. When they get to the factual background section, they already have read your intro and they're viewing it through the lens that you want them to view it through from the get-go. It changes things, and judges have time to do that. They may not have time to read through a 10+ page pleading, especially if it's an ex parte. So I try never to file anything that's over 10 pages if I can. Last but not least, don't send out a ton of written discovery. What you want to do is obtain medical records. You want to obtain financial records. You want to obtain the drafting attorney's file. You do those things with a subpoena. Easy peasy. Then you use written discovery limited to identify and obtain documents through request for production. And then you want to get the basic contentions of the other side and identify their witnesses so that you know who to depose. So I usually send out a limited amount of interrogatories that are designed just to figure out what the other side is claiming happened, their contentions. But other than that, I've found that written discovery is relatively useless. I've been in, I don't know, somewhere between 10 and 20 trials, probably long trials. I don't know that I've ever used written discovery questions and answers at a trial, other than to point out that the person didn't answer them fully, and so I guess that has some value, but that's it, right? One more exception though, and that is sending out requests for admission that ask the ultimate knockout question. Always do that, just in case. I've had cases where I got lucky and I sent out requests for admissions that asked for the ultimate issue. In this case, it was a guardianship estate matter. One of the issues was whether or not the father had abused the children. I asked him to admit that he abused them, admit that he would abuse them in the future if he ever got custody of them again, et cetera, et cetera. He fired his lawyer pending the responses. They were deemed admitted and the case was over. Doesn't happen very often, but that's one reason to at least ask them. So I always ask the ultimate question, right? Admit that so-and-so lacked capacity on such and such a date. The other reason is if someone denies that and then you successfully prove it up and they force you to go all the way to trial, you may get your attorney's fees coming back for having been forced to prove that their discovery was incorrect. Last year, my partner, Jennifer Hurley, and I successfully got an order of, I think it was approximately $350,000 in attorney's fees, based in part on that issue that someone had denied that they lacked capacity, when in fact, not only did they, but, opposite. They said they had, they said that the person did lack capacity. We were arguing they did not, and there were records showing that the person had been evaluated, diagnosed with Alzheimer's, but the conclusion was clearly, in layman's terms, that he retained capacity. So those are the greatest hits part. Hopefully you guys found some of those things helpful, and now I'll try to put a little more flesh on some of this stuff. The one thing to keep in mind is that all these people have different hats. The trustee manages, this is obvious, of course, The trustee manages the assets in the trust, and the power of attorney or the conservator manages the assets that are not in the trust. The trustee has duties. People always want to focus on the powers, but like Spider-Man, with great power comes great responsibility. And the main duty is that the trustee is to follow the trust as it's written, and follow California law. The trust is a plan that was created by the court. It is not the trustee's plan. It's not the lawyer's plan. It's not the judge's plan. It is the settlor's plan. And so the trustee should just be, it shouldn't matter who the trustee is. Whereas with a conservator, the only duty there really is to act in the best interest of the conservatee, who, by the way, is also usually the beneficiary of the trust in the situations we're talking about now, and more than likely the one who created the trust, which means it's all her money. Everyone else, from the conservator's point of view, should be able to be ignored in large part. So this page, the important parts here, I think, the thing that should really stick and everyone should keep in top of mind at all times is the least restrictive option language. That should just be burned into your brain as a lawyer dealing with conservatorships, because it should govern most of your thoughts and most of your arguments. Also, what we're talking about here is protecting the conservatee. I often hear attorneys and judges, frankly, arguing in terms of capacity or incapacity. And capacity is relevant, but that is not the standard for a conservatorship. It is right here. We are trying to protect someone that, in simple terms, cannot protect themselves, or we're trying to protect them from themselves. One or the other. Similar to that, what you've got to show is that the person is substantially unable to manage their own financial resources or resist fraud or undue influence. And so I would argue these are two things that are slightly different, right? If you're substantially unable to manage your own financial resources, that sounds a lot more like incapacity. You can't handle your affairs, right? But it's or resist fraud or undue influence. That's a little closer to proving that they're susceptible to influence and that people around them are trying at least to influence them. And so I think that second prong is a little easier of the two to focus on when you're trying to establish one. So it isn't incapacity. It's probably somewhere between susceptibility to undue influence and incapacity. The threshold issue being they have to be suffering from some level of impairment. It has to be interfering with their abilities to understand what's going on and make decisions. And so I think people too often argue capacity in like a binary black or white fashion, that someone has it or doesn't, when they should be arguing the level of impairment, kind of like a DUI, someone trying to determine how impaired someone is secondary to drinking, like determining how impaired someone is secondary to dementia or a head injury or whatever it is that's bothering them. I explain it that way to my clients. I've asked neuropsychs if that makes sense, and they've told me that it does, because if you are if someone's trying to determine impairment due to drinking, someone can have a drink or two depending on their weight and pass field sobriety tests and pass a blood test. But if they keep drinking, they're going to hit a point where they're legally inebriated, some people can still pass the field test at a point where their blood alcohol level hits that point. But if they keep drinking, at some point, it will affect their motor skills, and they shouldn't, by anyone's definition, be driving anymore. And if they keep drinking beyond that, not only will the field sobriety test pick it up, but it will be clear to anyone who sees them, that they should no longer be behind the wheel. And I tend to try to think of capacity in those same terms across the spectrum of impairment secondary to whatever it is that we're dealing with, and argue it like that. The other thing that really should jump out at everybody when you're dealing with conservatorships, and when you're trying to decide what you're going to do, is that the standard of proof is clear and convincing. And that should be ever present in your mind and how you're analyzing things. Because in my opinion, no one really knows what the heck it means. It's a little fuzzy, but I do know that judges use it like a club or a defense system, and that it is significantly more difficult to carry that burden than we're used to with preponderance. Another thing to take into consideration, just strategically, when you're dealing with these situations, if you have a conservatee who is cooperative and you're trying to protect that person and get them out of harm's way, you can have a voluntary conservatorship to have a conservator appointed who will then take the baton, take up the fight. Same with the guardian ad litem on the trust side. You can allege that while they're not 100% incapacitated, the rigors of litigation would be too much for them at this point in their life. And we should let the kids duke it out amongst themselves on their own dime, as opposed to allowing them to have a tug of war with grandma. And so I haven't used that often, but I have most often in the elder abuse situation, where where the client is fragile and the litigation is obviously bothering them a great deal. So I'm focusing on the money today, as I mentioned earlier, because that's what humans do. But you can do a lot of the same things I'm talking about with conservator of the person, or with advanced healthcare directives and petitions on those. For instance, to deal with visitation or isolation issues, I tend to want to get after those issues as early as I can, because if someone is nasty enough to play games with that and isolate grandma, they're not going to stop until someone makes them stop, right? That's a line that I shouldn't say most, but lots of people won't cross. And so once I have cards that show that, I tend to get after that pretty quickly as well. The other reason strike that. A related issue in terms of conservatorships. Why I'm not going to go really in depth onto the estate money issues. One is because of time, but more importantly, usually everything should be in the trust anyway. And so I often find myself saying, okay, well, if everything's not in the hands of the trustee, let's get everything into the hands of the trustee. And do we really need someone other than the trustee to protect the money? Sometimes we do, sometimes we don't. You get the classic lawyer answer, it depends there, right? Here, this is important in that if the conservatee has nominated someone and the nomination is valid, okay, we'll put aside claims that the nomination is invalid, then that person shall become conservator unless the court finds the appointment is not in the conservatee's best interest, right? Shall become. And this is that case again, Conservatorship of Ramirez. Read it. It's in the materials. Like I said, I have attached it as an exhibit to pleadings before because I want the judge to read it. I just have had it happen all too often where a lawyer stands up and says, Your Honor, we need a private professional because there's just chaos and the kids can't get along and they're firing caregivers and we just need a private professional. And the judge says, that's a great idea. I'm appointing one right now. And there's no evidence that the nominated person has done anything wrong. And that was the case in Conservatorship of Ramirez. There was a demented mom and son who were running a real estate empire. The son and the sister didn't get along. Sister filed for conservatorship. The rationale was allowing the son to be the conservator instead of a PPF would not bring peace to the family. And the court appointed a private professional, 2 professionals based on hostility. And the Court of Appeal said, not so fast, and sent it back down saying that when there is a family member ready, willing, and able to serve that has been properly nominated, absent evidence that they've mismanaged something or otherwise unfit, family member wins. Much to my chagrin when I represent private professionals, but that is the law. Again, the trust itself governs the limits of power that the trustee has. Read the trust, read it again, and when you think you know it, read it again, because your perspective will change as a case unfolds. And you need to let the judge know that the trust allows the trustee to do what he or she can do and what he or she cannot do as early as possible. You want to point out to the court, look, Your Honor, in a normal case, the trustee can't self-deal, but this trust says it can with respect to this particular asset. And I have had that come up way too often with attorneys that should know better. And so it's kind of my pet mantra, for lack of a better word. So similarly here, yeah, this absolute discretion language, you see this every once in a while in a trust, that the trustee's discretion is absolute and incontestable by anyone. Well-established law says that that's not the case, that it is evidence that the settlor wanted to give the trustee as much discretion as possible, but it's still governed by reasonableness. And so, again, you got to read the trust to figure it out, because sometimes it will say absolute. Sometimes it'll say prudent investor. Sometimes it'll say the trustee can hold unproductive property. Sometimes it'll say you can't distribute money to a beneficiary until you've exhausted all other sources of money. Other trusts will just say, no, the trustee has to take into consideration whether there are other sources. And so you really want, you just don't want to be arguing that the trustee can't do something because the probate code says so when the trust says she can. Here, definitely check out the CEB guide. They have a separate guide on durable powers of attorney. I believe my good friend Lara Heisler edits and or authors portions of that. There's some really good stuff in there, particularly the chapters about court proceedings that are relevant to what I'm talking about today. There used to be one of the chapters, I can't remember, I think it was the court proceedings chapter that was written by Commissioner Green when he was on the bench. And as a young attorney, I like to quote him to himself, although he didn't think it was as funny as I did sometimes. But it was entertaining to me anyway. this slide here is pretty self-explanatory and just compares the different vehicles, so you can read through that and understand it. So resolving conflicts, what specifically, what can we do when we are in a case that has conservators and or trustees that aren't doing what we want them to do? As I mentioned at the beginning, really what we do is we ask nicely, we give a deadline, and then we file a petition, usually a petition to instruct them to do what we want them to do, right? And I tend to give the person I'm directing that to a very short leash, right? A week, maybe 2 to comply. And if they don't, I file. You can always take things off calendar. You can always listen to overtures to settle at any time. But especially with the scheduling issues we're dealing with right now in certain jurisdictions, you want to get that date on calendar because that's what puts pressure on people. And like I said, I'll always take calls. I'll always talk about settlement. But in the meantime, I want to have Judgment Day on the calendar because people tend to find religion when they know that's coming. I also think, filing these petitions through the trust, filing a petition that asks the court to install a new trustee because grandma isn't the right person for the job anymore is a much easier argument than having to go through the process to conserve grandma. And oftentimes that will get you where you need to be, and you can always turn up the heat, but it's really hard to turn it down once you've opened that Pandora's box of the conservatorship world. But I've had that happen before where, it does happen where you file a trust action and you're hoping that gets everyone in line and they don't, they just keep misbehaving and you eventually have to go nuclear and file a conservatorship. But I just think it shouldn't be everyone's first move. It should be the last resort. And again, you always have available to you these petitions, petition for instructions with respect to trust, petition to authorize proposed action for conservatorships, and petitions to enforce triple power of attorney or to force someone to, recognize the authority of the attorney. In fact, you can do those things with specific separate petitions. In the trust setting, it's 17-200. Again, I think that a petition to determine that the trustee no longer has capacity to handle the trust day in and day out is an easier sell. You're basically saying, look, we love grandma, but this is tough stuff here. This is a large estate, whatever the rationale is. Running a trust is a lot harder than having the capacity to draft a will. It's a higher standard than testamentary capacity, where someone's saying, oh, out of all the things I own, I want to give this percent to this person and this percent to that person. To run the trust, you have to make a series of complex financial and contractual decisions day in and day out on an ongoing basis. And one should argue, I think, that one of the purposes of a trust is to provide that procedure, that handoff of the baton when the settlor reaches a certain point in life. I've often joked about it. I don't know if I would actually do it, but I've often joked about writing that message into my own trust and as a message from young Joe to old man River Joe, saying, once you get to, whatever the age is, 75, you might want to start thinking about handing things off to your kids or those other trusted people that you named when you set this darn thing up. And there are worse things than having someone pay your bills for you. My wife's already basically my conservator now, right? Or I haven't written a check in like 10 years. So it's not that bad. Although I have to admit that when I use that analogy, conservatees don't think it's very funny. So you can use 2580 to petition to authorize proposed action in the conservatorship setting. It's basically like a petition for instructions in a trust setting. You can do a lot of the same things. Get creative about doing that if you don't like what the conservator is doing and you represent the trustee or someone else. Just like the conservator can do a petition for instructions because they are the conservatee who is a beneficiary under the trust. Similarly, you can do petitions under the power of attorney. They're in the 4,500-ish area of the probate code. One important note with agents, though, is that agents may not override the expressed wishes of a principal. So if the elder, even though demented, is able to express their wishes and desires, and they say, I do not want to do what my agent is doing, the agent cannot legally override those wishes. Only a conservator has the power to do that. So the classic example would be, in my experience, agents can't put someone in a nursing home over their objection. If you have an elder who's in a home because their kid put them in there and the elder's saying, let me out, they're going to get out sooner or later. The problem is that doctors, nursing facilities, and lots of probate lawyers don't know that. Part 3, avoiding the conflict. So this is the probably the most obvious and the shortest part. I'm almost done here. In my opinion, in my experience, good estate planning can't prevent a conservatorship. Someone can always go try to blow it up, but it sure as heck helps, right? It helps you try to get the conservatorship denied or at some point terminated. It's another point to keep in mind that even when one's established, it's not the end of the world both ways. Someone could always terminate it, petition to terminate. Someone can always, even after you terminated it, say 2 more years, they've worsened. Now we need the conservatorship again. It's kind of the double-edged nature of conservatorship practice. But, definitely estate planners can identify known issues in the estate planning documents themselves so that there are signposts for a court later to say, hey, the settlor saw this thing coming and this is how he or she planned for it. I don't do a lot of planning these days, but I would, if I did, encourage clients to have tough discussions with family members while they're still alive, instead of leaving this time bomb of disinheritance ticking because that they don't want to have those difficult conversations. If it's explained to them, no one wants to have that conversation, but if it's explained to them, if we don't do this correctly, your awkward situation could end up evolving into, $400,000, $500,000 in litigation between your kids when you're not around. Maybe you can convince a couple of them to do it. Another thing that I strongly suggest everyone to do is Andy Verrier wrote an article, it's posted online somewhere, about the preemptive use of trust petitions to confirm validity preemptively and barring contests post-death. He and I had worked on a case several years ago where we did that because our client was going abroad for several months or maybe even longer. And we wanted to establish the validity of the documents as a bar to a conservatorship action, a sneak Pearl Harbor type conservatorship action. So I would encourage people to read that, pick Andy's brain if you're ever around him, and read pretty much everything he writes, because it's generally good stuff. I've beat the heck out of this subject here, why I don't think they're always the answer. And you can read that. So with that, I went over a little bit, a little over an hour, I think, but I'm ready now for any questions anyone may have.
Right, thanks, Joe. So we had actually one question, then a Q&A. What do you do if there are good alert days and many no memory days? I'm guessing that goes to estate planning or conservatorships, capacity issues.
Hold on 1 second, because I was trying to turn off the slideshow and I don't see where. Oh, I need to stop the share. Sorry, having technical difficulties. What was the question again?
What do you do if there are good alert days and many no memory days? I think this person's asking potentially about capacity.
Yes. That's a very good question. I mean, I guess they mean in the context, I guess I'm unclear about whether they mean in the context of drafting wills and trusts or conservatorships, but obviously there's a presumption of that everyone has capacity, and then there's a presumption that if they do have something that's affecting them, like a dementia or Alzheimer's, but they do have periods of lucidity, the presumption is the document they signed was signed during a moment of lucidity, and the contestant has the burden of proving that they were not lucid at the moment of execution and zooming in directly at the moment of execution. With respect to documents, I think that usually for me highlights the importance of whether or not a lawyer was present when the document in question was executed.
So Joe, there's a follow-up
yes.
to that. The question was when the question came in when you were talking about the conservator's decisions. About 15 minutes ago.
Yeah. So I'm not certain. I'm not sure how to answer that. Maybe they were talking about when about the conservator's expressions, wishes and desires, maybe. In that case, we're supposed to, the court is supposed to honor the expressed wishes and desires of an elder, whether it's in the conservatorship realm or otherwise, unless doing so would not be in their best interest. So that's what you have to end up arguing about is, okay, is what they're saying. I mean, almost everyone can express their wishes and desires until the moment they expire, right? The issue isn't, people always will say that, oh, well, so-and-so, they said they wanted to do this. And my response to that is generally, that's not the question. Of course, they could say what they wanted. It's does what they've said make sense, right? Can we tell whether they understand the consequences of that, of carrying out that expression of desire, or not, right? And would doing so be harmful to them? And if it is, it's a tough question because, I, right now at the age of 52, should be able to do things even if they're harmful to me, as long as I understand that they're harmful to me. And I tell people all the time, everyone has someone that has influence over you. My wife has a great deal of influence over me, but she can't make me do things I don't want to do. Fast forward 35 years, add in some dementia and reliance on, like real reliance on people around me, all of a sudden I'm susceptible to her influence and maybe she can, and that's where that question comes in, is if I'm as an elder and I'm seeming like I'm out of it all the time, and every once in a while I'm okay and I say things, well, then I think we need to zero in on, well, do we have witnesses that say the person was lucid at that time? And then just in the abstract, does what I'm saying make sense? You know, can we show that I understand the consequences of the transaction or the decision? Hopefully that answers the question.
Okay. Hopefully it does too. If that didn't answer the question, please tell me in the chat. So there's another question. Are you saying that we need a conservatorship to move grandma out of her house, even if you have a healthcare director nominating the client as an agent if grandma doesn't want to move out of her house?
Yes. Yes. And even with the conservatorship, I mean, you can move them if you have the power, but you have to file, notice of move, and it's supposed to be in an emergency. You're supposed to, before you move people out of their home, your prudent thing would be to seek prior approval, because medicine and the law both, in my opinion, really agree that all things being equal, keeping people in their homes is better than moving them to somewhere that's unfamiliar to them, especially if they're dealing with dementia. That what's happening is their brain is malfunctioning. And if every day they wake up and they don't know where they are, that tends to disorient them and agitate them. And it's kind of a spiral. It's very common for people to really go into a tailspin shortly after they've been moved out of their home, especially if there's somewhere where they've been for a long time. So I think the short answer is yes. And the long answer was that babbling, rambling response I just gave afterwards.
And the last question we have is just the person wanted to confirm that you can't use a durable power of attorney against the principal's wishes.
Correct. I mean, I think you could, you could get a court order that you could, I believe, or if the person was completely incapacitated, obviously but to the extent that they can weigh in, I think that's when you have to move to the conservatorship. So yeah, that's my understanding.
Okay. And looks like that's all the questions we have. So last call for questions in the Q&A or the chat.
I'm so proud of myself that I finished on time.
All right. I don't see any. So Doug and Ann will turn it back to you guys.
Thank you, everyone.
Thank you, Joe. That was great. Thank you, Ritzy, for getting this together for the section and for fielding all those questions. And Doug, just thank you for being you. And we will I'll send out the attendance certificates and evaluation forms and things in the next day or so. And look forward to seeing you all again very soon.
Hey, Ann, I got one last announcement on that.
Oh, that's right. I was going to say that. Go ahead. Yeah.
Yeah, no, I forgot to say this in the first go around. So the elder law and the estate planning section are doing a joint holiday mixer. So set your calendars. It's December 1st. Time and location will be determined at a later time, but we wanted to get it kind of ahead of the game. So December 1st, a joint shenanigan holiday extravaganza.
Doug, December 1st.
That's what I said, December 1st. Exactly. Thank you, Ritzy, as always. December 1st.
Also, the elder law section is doing a great program on the new conservatorship laws for the MCLA Spectacular. So stay tuned for that. And we will we'll hopefully see you all there. We're getting really excited for the spec, and we'll be getting the programs and registration information out to you very soon, likely mid-September. So stay tuned for all of that. And thank you all. Have a great rest of your day. And I think the word is stay off 680 southbound between the bridge and Pacheco for now. Still bad traffic. So thanks, everybody. Talk to you soon. Bye-bye. Thank you, Joe.
Thank you.